Good afternoon, everybody, and welcome to Franczek's first ever Supreme Court Review webinar. You know, we at Franczek have been issuing the Supreme Court Review for quite a while now, but this is the first time that we're getting together to present it as a webinar, and I am thrilled to be here to do so. My name is John Swinney, and I am an associate at Franczek. For those of you who are not familiar with our firm, Franczek is a law firm of approximately 40 attorneys who focus on labor and employment, education, and immigration law. And I'm thrilled to be here today with my friend and colleague, Leah Farmer.
Hi, everybody. It's a pleasure to be here. I reiterate John's sentiments. It's very exciting for us to be able to talk to you all about the most recent SCOTUS term and the important labor and employment decisions from that term. Before we get started, there are just a few housekeeping items to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. If we don't have time to get to your questions, we've also included our email addresses near the end. We have a lot to talk about in the hour. We're very interested in your questions, and if we can't answer them here on the webinar for everyone, we certainly welcome your questions afterwards. This program has been approved for HRCI, SHRM, and CLE credits. Please fill out the survey that will be emailed to you after today's webinar to receive professional credit. Additionally, everyone logged into today's program will receive an email that includes a link to the recording of the webinar as well as the presentation. John and I are both certain you'll want to listen to this a few times because we plan to be very engaging.
Definitely. Well, with that, let's jump into the presentation. So as you can see here, today's presentation will generally be split into three different sections. First, we have the overview of the term, which is our kind of 30,000-foot overview of just what happened this year with the Supreme Court. Then we'll get into case highlights. That's the portion of the presentation where we will talk about the court's decisions that specifically impact labor and employment and what you need to know about them as employers or employees if you're on. And finally, we'll look ahead. And in that section, we will talk about the labor and employment cases the court has already agreed to take. And we'll briefly touch on Judge Kavanaugh's appointment, or nomination better, to the Supreme Court in order to fill Justice Kennedy's vacancy.
So we'll go ahead and kick things off, like John said, with an overview of the October term. So the Supreme Court in this term saved two of its biggest decisions for the last 2 days of the term when it released both Janus and Trump versus Hawaii. We saw in this term a slight shift in labor and employment decisions from what we were seeing in some of the previous terms, you know, from a unity standpoint. For example, this term, out of the 7 labor and employment cases that we're going to highlight, 4 of those 7 were split 5-4. It's a little different from what we saw in previous years. In 2013 to 14, we had 6 of 10 unanimous labor and employment decisions. And in 2015 to 2016, we had 6 of 11 unanimous decisions. In this term, we have 1 unanimous decision and 1 per curiam decision. So we saw a little more split, a number of 5-4 cases, and those were often, as you might imagine, down ideological lines, although they weren't exclusively throughout the term down ideological lines. In a case we're not talking about today, South Dakota versus Wayfair, we saw Justice Ginsburg switch sides and join with the more conservative, some of the more conservative justices, Thomas, Alito, and Gorsuch in a Justice Kennedy opinion, while Chief Justice Roberts wrote a dissent that was joined by Justices Kagan, Sotomayor, and Breyer. So not every 5-4 split across the court was down ideological lines, but we saw a sort of consistent ideological split in the labor and employment decisions.
And Leah, I would just highlight, too, that when we talk about these splits, when we talk about these decisions, today's focus really is on labor and employment. So while we may not be presenting on the general, composition of the votes for all cases in the Supreme Court this term, we do know that the labor and employment decisions were split more amongst ideological lines than what we've seen in the past.
That's absolutely right. A couple of the other things that we'll highlight during our time and sort of looking ahead, we'll talk, like John said, about the nomination to fill Justice Kennedy's seat, but one thing about this term that will be unique was it was Justice Gorsuch's first full year on the term, or on the court, and, I think the court felt the impact this year. So, throughout these case highlights, we'll be talking about Justice Gorsuch's impact on the bench as well.
All right, so let's get into it. Beginning with the case highlight section, again, this is the portion of our webinar where we will discuss what labor and employment cases came before the Supreme Court and how they ruled, and probably most importantly, what impact that has on you. In general, there were 7 cases that we think made a big impact on labor and employment this term. And we've outlined them here. We'll obviously go into more detail on each of these cases as we continue on in today's webinar. But we did want to provide just kind of a one sheet, in case later today, later this week, you're thinking, what did John say those 7 cases were that were important? Well, here they are. You can look back. This is for your reference.
So we're going to kick off today starting with C&H Industrial NV versus Reese. One thing you'll hear us say throughout today is that some of the court's decisions on labor and employment were more narrow decisions, and our first case is definitely an example of that. This case is of particular impact for any of our listeners in the Sixth Circuit, Kentucky, Michigan, Ohio, or Tennessee. This decision was our one per curiam decision issued by the court as opposed to single justice as well. So in this case, retirees and spouses of former employees filed a lawsuit seeking a declaration that their health benefits were vested for life. The CBA at issue provided health care benefits to only certain employees who retired under the pension plan, but stated that all other benefits ceased as of retirement. The plan itself was silent on whether health care benefits vested for life, but it did include a statement that it disposed of all bargaining issues and had a general durational clause that expired in 2004. So when that happened, when it expired, is when we see the lawsuit being filed. In this case, the question that the court was really asking is, should a court use inferences to determine whether a CBA is ambiguous? As is often the case, there was a little bit of backstory to that question. This case was not, or this issue in particular, was not new to the Supreme Court. In 2015, during the term there, the Supreme Court struck down part of the types of inferences the Sixth Circuit was still using, which were referred to as yardman inferences. So in 2015, the Supreme Court said those inferences were inconsistent with ordinary principles of contract law because they assumed that retiree health benefits were like a pension and served as a form of delayed compensation, even when that wasn't consistent with the language in the agreement. And general principles of contract interpretation don't usually allow that sort of inference. The idea is that you look at the 4 corners of the document and determine whether inside of the document there's any ambiguity. So following the decision in 2015, the Sixth Circuit refused to put the yardman inferences to sleep, and as the majority said in its opinion, this case presented yardman reborn, rebuilt, and repurposed for new adventures. Not really sure what those adventures would look like, but John and I would love to see some of them, I think.
I definitely would. Yardman reborn sounds fun to me.
Right. So here, the Sixth Circuit in this decision following Tackett, rather than using the inferences to presume the benefits vested, they used the inferences to presume the contract was ambiguous. And in this per curiam decision, the court said no. In analyzing a CBA, just like any other contract, the principles of ordinary contract law should apply, and external inferences should only come in a truly ambiguous case. And here, shorn of the yardman inferences, this case was pretty straightforward.
Again, though, limited only to the Sixth Circuit.
Absolutely, John.
All right, well, moving on to the next case then, we have Digital Realty Trust v. Summers. Now, in order to understand this case, we do need a little bit of background information. First and foremost, this case involves the Securities and Exchange Commission, or the SEC. And the SEC is responsible for protecting investors and maintaining fair and efficient markets. And they do so by enacting different policies and by trying to prohibit certain actions such as insider trading. And in the wake of the 2008 financial meltdown, Congress passed the Dodd-Frank Act. And the purpose of the Dodd-Frank Act was to provide protections to employees who reported SEC violations and then to offer those same employees incentives to do so. So when we're looking at this case, we really are talking about a decision that's mainly going to impact companies that are publicly traded. I mean, that's really where the SEC comes into play and what this decision will impact. Now, since the passage of Dodd-Frank, there has been rather extensive litigation and debate about whether the whistleblower protections under the Dodd-Frank Act protect employees who report violations of SEC violations to either their employer or to the SEC directly. Rephrasing that, the question really is, do you need to report directly to the SEC in order to get the protections of a whistleblower? And that's exactly what this case was about. So here, Paul Summers was an employee of Digital Realty Trust. He reported that there were some alleged SEC violations, and sometime after making that report, he was terminated. In response to that, he filed a suit claiming that he had been retaliated against as a whistleblower and terminated. Now, when the case made it to court, Digital Realty Trust moved to dismiss the case, saying that no, Summers only reported the SEC violation internally, and therefore, under the language of the Dodd-Frank Act, he could not be a whistleblower. And that's what the court was called on to answer here. Are employees who report SEC violations internally still protected as a whistleblower? Now, I do want to take just 1 minute here to differentiate that when we're talking about whistleblower protections right now, we are only talking about whistleblower protections under the Dodd-Frank Act. There are other laws out there that pertain to labor and employment that do provide for whistleblower protections and that will not be impacted by this decision because this decision was based solely on the language of the Dodd-Frank Act. And the court concluded, after looking at the language, that yes, to be a whistleblower, you do have to report directly to the SEC. Internal complaints of SEC violations do not provide whistleblower protections for employees.
And John, in some ways, what do you think the impact of this is to employers? Weren't there some benefits from internal reporting?
There definitely were. So, we have a statistic that the SEC actually promulgated that 83% of whistleblowers who received SEC awards under the Dodd-Frank Act, as I said, the Dodd-Frank provided incentives for employees to actually report SEC violations. But 83% of those individuals first reported the violation internally. And really what that did was provided employers with a chance to get ahead of really any complaints that would have been made to the SEC to know, okay, we have something that might be an issue here. The employees flagged for us. Do we need to look into this? Do we need to take care of this right now, before it gets escalated? This decision may, we don't know, but it may drive employees to make reports directly to the SEC. And if that happens, employers may lose a valuable opportunity to actually get ahead of these complaints. But again, we don't know how this will turn out. That is an option, though.
Next on our list of important cases to talk about, we come to Encino Motor Cars, LLC versus Navarro. This decision came out in April of 2018, and it's worth highlighting for a couple of reasons. First, the holding certainly impacts the class of employees who are newly deemed exempt from the overtime requirements of the Fair Labor Standards Act. But second, it marked a shift in the applicable standard for interpreting exemptions to the FLSA overtime requirements. In this particular case, the service advisors at a car dealership in California sued back in 2012, saying that they were misclassified as exempt under the FLSA. The FLSA, for those of you who don't have it committed to memory, exempts any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles with the caveats that those be in non-manufacturing positions and that the person be selling to the ultimate purchaser. So certainly, you know, people selling the cars at car dealerships were clearly under that exemption, but it was unclear what other positions who were similar but not clearly enumerated in the FLSA might fall, like service advisors. This case is also interesting because it was no stranger to the Supreme Court. It first appeared on the docket in 2016, where the Supreme Court sent it back down to the Ninth Circuit to reconsider. The Ninth Circuit, in its original decision, had relied very heavily on a 2011 Department of Labor guidance, which the court found invalid. So they sent it back down to the Ninth Circuit with the instructions to reconsider without relying on that guidance. And the Ninth Circuit reached the same decision again. Service advisors were not exempt from the overtime requirements. So when it came back up to the Supreme Court, we have another example of a 5-4 decision, but ultimately the majority disagreed and reversed the lower court, finding, you know, the question here was going to hinge on, are service advisors salesmen primarily engaged in servicing automobiles? If yes, then they were going to be exempt from the overtime requirements, and that's ultimately what the majority found in an opinion authored by Justice Thomas. Service advisors were salesmen who were servicing automobiles, selling the parts, the pieces, the repairs to consumers for their automobiles. However, that decision, you'll hear us say a few times today, is a pretty narrow holding. It specifically only addresses service advisors at car dealerships. Perhaps the more interesting part of this decision is something else that the majority did. They flatly rejected the narrow construction doctrine that had been in place since 1945 for interpreting the FLSA and which exemptions would apply under it. Back in 1945, the court's decision in A.H. Phillips Incorporated versus Walling set forth a narrow construction doctrine whereby any exemptions to the FLSA had to be plainly and unmistakably within the Act's terms. And in this case, in Encino Motor Cars, the majority said no more. Justice Thomas introduced a concept of a fair reading. And he said that under the FLSA, the court had no license to give the exemption any more than a fair reading. The dissent in this case, authored by Justice Ginsburg, chastised the majority for this, finding not only under a plain language reading that the service advisors should not have been exempt, but primarily focusing on this shift from past Supreme Court precedent and stare decisis, which is something that we'll mention a couple more times today that came up in a number of these labor and employment cases.
So, Leah, this may be an obvious question, and I'm sorry if it is, but it seems to me then that even though the ruling in this case was narrow, this might have a broader impact overall in terms of the FLSA?
I think it certainly could. It'll be interesting to see what happens as lower courts start trying to apply this new fair reading standard as opposed to the narrow construction. It certainly gave license to find exemptions from the Fair Labor Standards overtime requirements that courts previously would not have been able to.
Right, yeah, that's interesting. All right, well, moving on to the next case, we have Epic Systems Corp. v. Lewis. And in my humble opinion, this might be one of the most important L&E cases that we saw this term. So this case deals with the Federal Arbitration Act, the FAA, and I only mention this now because as we'll see later and as we'll discuss later on in this webinar, the court currently seems to be almost fixated on the FAA when it comes to labor and employment, and in defining the parameters of arbitration agreements and who gets to decide the enforceability and the parameters of arbitration agreements. So while this case is certainly important on its own, it is, and we'll go into detail on that in just a minute here. This case is also important because it kind of shows what the court is currently thinking and where the court might be headed in the next term when it starts to look at more FAA cases. But starting with the facts of this case, Epic Systems Corp., which I'm just going to refer to as Epic, had an employment agreement that required its employees to agree to individual arbitration, meaning that they couldn't bring a class arbitration. It had to be one-on-one. Lewis, who was a former Epic employee, sued Epic in federal court individually and on behalf of other similarly situated employees for denial of overtime wages in violation of the FLSA. So he brought a class action in federal court. Epic moved to dismiss the case based on the individual arbitration clause in the agreement, but the employees at Epic argued, and the trial court agreed, that the arbitration clause was unenforceable because it violated the employee's right to concerted activity under Section 7 of the NLRA. Now, I'm sure almost everybody here knows what the National Labor Relations Act is, but just as an overview, Section 7 of the NLRA does provide employees the right to engage in protected concerted activity. And so here, the argument that the employees are making is that, look, we have a right to band together for our mutual benefit. This class action is for our mutual benefit, and we're banding together to bring it. How can you say that we can't do that under Section 7 of the NLRA? The Seventh Circuit agreed with that argument and found that, no, this agreement violated Section 7 of the NLRA and was, therefore, unenforceable. So the question on appeal to the Supreme Court then is, do these individual arbitration agreements violate the NLRA? And I guess more broadly, can employers have individual arbitration agreements? Is that okay?
John, so we know just generally that if given two potentially conflicting statutes, the court may look for an interpretation first that allows them both to exist. Did you see signs of that in this case?
That certainly happened here. So I'll flip ahead to the decision here. In coming to this decision that, no, the NLRA does not preclude these FAA individual arbitration agreements, they really did try to give effect to both statutes. And they said when Section 7 of the NLRA was enacted, they didn't consider collective arbitration to be part of that collective action. We can give effect to both of these statutes without them conflicting. The other interesting thing that the court did was commented on Congress's mandate that the court really give effect to arbitration agreements and respect the FAA, which historically the court has done, and we see again in this case, they're respecting the FAA, giving effect to an arbitration agreement. However, it is interesting to note, and Leah, I can tell you're about to point this out, Justice Gorsuch did make a comment, and I quote, "You might wonder if the balance Congress struck in 1925 between arbitration and litigation should be revisited in light of more contemporary developments. You might even ask if the Federal Arbitration Act was good policy when enacted."
It sounds like even in authoring the majority's opinion, he's not entirely sure the use of the FAA and...
Definitely. There appears to be some skepticism there as to how useful the FAA might actually be. And in dissent, Justices Ginsburg, Breyer, Sotomayor, and Kagan band together to say, look, we don't buy this. The NLRA clearly protecting concerted activity, and that's what this is. They're banding together to bring a case. How is this not covered?
I think, one thing that might be interesting here, certainly the majority opinion takes precedent, but as we see more FAA cases coming to the Supreme Court in the future, the dissent in this case may start to become relevant depending on whoever the new justice is, how the new split works out, and what everyone's really thinking about the FAA. So we may see some additional fights to both the majority and the dissent opinions.
Definitely, and not to tease you all too much, but yes, there is a lot of arbitration coming down the pipeline, so this could come up very easily in the future.
So after Epic Systems, we come to another one of our sort of blockbuster cases from this year's term, Janus versus Axne. We won't talk too much about Janus today because a webinar on just this case took place last week from our firm, and you can find that link on our website, www.franczek.com. Although if you're anything like us, you've probably already listened and committed it to memory. But if not, the link is up there. You have an opportunity to go listen, and it's a great opportunity to really dive deeply into, what this case says and does. and the impact it has. But we'll take, like John said earlier, more of like a 30,000 foot view today. So it's just a quick summary. This case was primarily about the legality of fair share fees paid by government employees represented by a union for collective bargaining purposes for which they did not belong to the union. They didn't pay regular union dues, but they could still be required to pay a fee to cover the cost of collective bargaining. And so the question here was, did that violate their First Amendment rights? And the majority said those fair share fees are not okay. That requiring fair share fees violated the First Amendment rights of the objecting members. And this decision overruled Abood versus Detroit Board of Education from 1977. And so when we mentioned earlier that you'd hear us talking some about precedent and changes in precedent, this is another of those examples. But also, as you might expect from another 5-4 split and another changing of Supreme Court precedent, there were some pretty passionate dissents in this case as well, including one from Justice Kagan, where she accused the majority of showing little regard for the usual principles of stare decisis, which might start to sound a little familiar since we talked about very similar matters from Encino motor cars as well. And it won't be the last time that we talk about it today either.
And Leah, just before we move on, I do want to point out, though, and maybe you can touch more on this, but Janus, as much of a blockbuster as it was, and it was covered in the news like crazy, it really was a limited scope.
Absolutely. So, Janus, in effect, impacts government employees in unions, in public sector jobs. And
in states that are not already right to work.
Absolutely. So, that's already a fairly limited number of individuals who will be impacted. And it's important to say it's a very important change for those impacted by it. The changes took effect immediately. But for anyone else, for private sector unions, for non-right-to-work states, the impact is unknown at this point and may be fairly limited. My guess would be we'll start seeing more states pass laws having to do with fair share fees and the responsibility to represent non-members. We certainly could see another case work its way through the courts that addresses how this impacts private sector unions, but for now, this decision is really just limited to public sector unions' practice of fair share fees.
Right, and to give another plug to our colleagues, they really did dive deep into this case. So if you do get a chance, Franczek.com, the webinar is very good.
So since this is a First Amendment case, or decided on First Amendment issues, Janus, it's a nice segue right into our next case, which is Masterpiece Cake Shop versus the Colorado Civil Rights Commission, another labor and employment decision from this term that looked at, an L&E issue through a First Amendment lens. This case also, similarly, was another highly covered, highly publicized case that, in effect, actually had a very narrow ruling. So I know maybe we're starting to sound a little bit like a broken record with our blockbuster case, really narrow ruling, but in a lot of instances this term, that's really what we saw was a majority decision that ultimately really took a very fact-specific look at the case in front of them. In this particular case, Masterpiece Cake Shop, a baker in Colorado refused to bake a cake for a same-sex couple's upcoming wedding. And, the question that was theoretically presented by this case was, does the Colorado Public Accommodations Law require him to make that cake if he says it's a violation of his deeply held religious beliefs? So while that was the question presented, that isn't the answer we got. So while the court had the opportunity here to potentially answer a broader question, it largely punted on answering under what circumstances, if any, a business may refuse to provide services to or employ individuals based on sincerely held religious beliefs, which would be protected by the First Amendment, but could also conflict with anti-discrimination laws. So this case is not going to be, the case that answers those questions. The majority here was 7-2, and the opinion was authored by Justice Kennedy. who you may recall also authored the majority opinion in Obergefell versus Hodges, the landmark decision from 2015, which held that the right to marry is guaranteed to same-sex couples under the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So for many, and when we talk about Justice Kennedy and his legacy, the legacy of same-sex civil rights is part of, Justice Kennedy's legacy. And so people had all sorts of theories about where he would go with this case, what the impact would be. And largely, Justice Kennedy took a very narrow approach. Looking at the facts here, he found that the Baker didn't receive a fair and neutral hearing from the Civil Rights Commission. Members of the Civil Rights Commission made a series of comments that were certainly not religiously neutral and were a little antagonistic to the Baker's defense of religiously based objections. Comments from the commission included calling the Baker's First Amendment defense despicable or akin to defenses used to justify slavery or the Holocaust. And those comments, the majority said, kept the Baker from getting a fair hearing. And so in this case, the majority largely punted and simply said the Baker was entitled to a fair and neutral hearing, which he didn't receive, and sent it back down for a new hearing.
And continuing on that theme of cases that had decisions that were not truly decisions, we get to the last big case that we're going to discuss for today.
I don't know what Justice Roberts would think about saying it's not truly a decision.
Right. Well, we'll track that statement then. But Trumpy Hawaii, this is a case that everybody has heard about. It's been in the news. This is the case that dealt with President Trump's executive orders on travel, or commonly referred to as the travel ban, which I will probably call it throughout this presentation just for ease of reference. A little bit of background facts, which again I'm sure everyone knows, but President Trump entered 3 different executive orders that restricted entry into the country. And throughout the country there were different nationwide injunctions that prohibited those executive orders or those travel bans from ultimately going into effect. Just for a point of reference, the most recent restriction restricted entry on individuals from Venezuela, Libya, Syria, Iran, Yemen, Somalia, and North Korea.
That was a little bit of a change from some of the countries on his first list. Those countries aren't exclusively, primarily Muslim-based countries.
Right, and initially one of the complaints was that the initial list was almost exclusively countries that are Muslim countries. So there was an establishment clause issue, which we'll get to right now. The questions in this case were really twofold. First off, do these executive orders, do these travel bans violate the Immigration and Nationality Act, or the INA? And second, do the executive orders violate the Establishment Clause of the United States Constitution? As a background, President Trump cited to the INA as his authority for issuing these executive orders. And really what the INA does is grants a broad discretionary power to the President of the United States to restrict entry of aliens into the United States for various reasons, one of which is national security, and that happens to be the one that President Trump cited to. The Establishment Clause, for those of you that don't know, is a part of the Constitution that basically says that Congress shall not enact any law that either establishes a religion or favors one religion over another. And so the argument that was made here was that the executive orders basically disfavored individuals from Muslim countries, Islamic countries, and that it didn't allow them to enter the United States. So those are the two arguments. They wanted to know, did he overstep his authority under the INA, even though it's broad, and did this violate the Establishment Clause? Now, earlier when I said it was a decision that's not necessarily a decision, what I should have said was it was a decision on the preliminary injunction. It was not technically a decision on the merits of the case. So the court did take a strong stance, though, in coming to the conclusion that the preliminary injunctions should not have been granted. The court did find that the president did not act outside of his authority under the INA, and that the likelihood that the plaintiffs could succeed on the merits of their Establishment Clause claim were very, very low. Ultimately, that led the court to say, look, we're overturning these injunctions and remanding the case back down to the lower courts to determine whether or not they should proceed with litigation. We don't know if they will. The opinion of the Supreme Court is pretty strong that they don't think anything here was violated, but it is possible that this could continue in the lower courts now.
One thing I think is interesting that kind of ties this case back to Masterpiece Cake Shop. So that decision, Masterpiece Cake Shop, came out in April. We know Trump versus Hawaii came out in the last, the very end of the term. But in Masterpiece Cake Shop, the majority focused its opinion on the sort of clear and impermissible hostility made by public official statements that were not, religiously neutral in their face, even though the law was neutrally worded. And so back in April when Masterpiece Cake Shop came out, a lot of commentators and analysts started saying that maybe they expected that to be laying the groundwork for the majority opinion here in Trump versus Hawaii, but we didn't really see that, did we?
No, and I've read a lot about really the impact of this case, and one thing that some commentators are speculating is that, on remand, when this case does go back, Masterpiece Cake Shop, and really honestly what the court looked at in this case, might provide a foundation for the lower courts to look at President Trump's campaign speeches and extrinsic evidence to determine whether there was animus behind these executive orders. The court may have laid a foundation for that, is what some commentators are saying, and I guess we'll see. Just as a point of significance for our employers, really what this means is that if you have an employee that is from one of these 7 countries that's listed, we really at this point would discourage international travel. And you should let your employees know that until things are clarified or until things die down, external, traveling outside the United States is probably not the best idea right now. And if you have questions, this is a good case to get in touch with your legal counsel on just to see what the impact might be for you specifically.
I think one more thing we should mention before we move on is we saw some overturning of Supreme Court precedent in this case as well, didn't we?
We did, yes.
We promised we'd keep talking about it, but the majority took the interesting step in this decision of overturning Korematsu, right?
They did. So the dissent, which was authored by Justice Sotomayor, was very passionate in this case and compared the decision of the majority to Korematsu. And for those of you that are not familiar, Korematsu was the decision authored in 1944, I believe, by the World War II Supreme Court that said internment of Japanese Americans was permissible under the president's executive powers. The dissent likens this decision to Korematsu, which is very strong, I think, and in response, the majority explicitly overruled Korematsu, saying, no, Korematsu was wrong the day that it was decided. It's wrong today, and so we are overturning that precedent, which I'm not sure if this is technically an official way to overturn Supreme Court precedent, but I would hope a court wouldn't follow it anyway.
Seems like Chief Justice Roberts did not like that reference to the dissent.
I don't believe he did.
So those, ladies and gentlemen, are the main cases from the 2017 October term that we thought had a definite impact on the L&E field that deserved sort of a summary. But it is not the end of our webinar, so keep a hold of your seats because we have some really exciting things to talk about from the cases where the court has already granted cert for next year. So snapshot, sort of high level again, we've identified 4 cases where certiorari has already been granted, and it merits sort of keeping an eye on to see what happens. John and I have been calling this Mount Lemon and everything else, and the reason for that is Mount Lemon, the first case you see on your screen there, is actually the only of these 4 cases that isn't hinging on the FAA and the Federal Arbitration Act. So as we've not so subtly hinted throughout, we really expect the court to continue looking at the FAA, and as Justice Gorsuch may have flagged for us in his opinion, how rightly decided it was when Congress first passed it. If the Supreme Court takes only these three, Henry Schein, Lamps Plus, and New Prime FAA cases in the next term and takes as many cases as it would normally take, we could see the FAA equal somewhere between 3 and 5% of the Supreme Court's entire docket for the term, which would be a really high jump.
Yeah, that would be significant for sure. Well, starting with the first case that is not dealing with the FAA, well, we'll start with Mount Lemmon Fire District v. Guido. So this case is actually an ADEA case. And just as a little bit of background, the ADEA, as originally enacted, applied only to private employers with 25 or more employees. That was what they called the numerosity requirement. And it expressly excluded states and political subdivisions of states from its requirements and protections. In 1974, however, Congress did extend the ADEA to lower the numerosity requirement first off from 25 to 20 employees, and then to extend the protections to both federal agencies and state governments and their political subdivisions. Since the 1980s, though, the Equal Employment Opportunity Commission, or the EEOC, which is tasked with enforcing the ADEA, has taken the position that the 20-employee minimum does not apply to political subdivisions. And this goes back to really when the 1974, extension of protections went into effect. The private sector protections clearly have a numerosity requirement. It's enumerated right within the section. Whereas the extension to political subdivisions and to federal agencies, they did not include direct language to say there's also a numerosity requirement here. So the EEOC has interpreted that language to mean that there is no numerosity requirement. Therefore, any federal agency or political subdivision of a state is covered by the ADEA and its requirements, regardless of the number of employees that it employs.
We talked a bit throughout the day about the court issuing some very narrow holdings. Do you think this case is potentially ripe for another one?
This definitely is. So there's actually a factual question with this case, too, as to whether or not Mount Lemmon Fire District actually employs more than 20 individuals. It seems that there's a dispute that the pay records from Mount Lemmon have more than 20 individuals listed as employees, and that there further are volunteers who are given a compensation package, more or less. So this case could turn on the court saying, look, while this issue is very interesting, you employ more than 20 people, you're past the numerosity, this is what this case is going to turn on. We'll see, though. We'll see how the court comes out on that one. But regardless, this will be interesting for public employers to determine, if you employ less than 20 people, are you covered by the ADEA? That's an interesting question, I think.
It would certainly change, the sorts of policies you'd have to have in place and, what your practices are regarding, the ADEA and employees on your team.
For sure.
So this takes us to Henry Schein Incorporated versus Archer and White Sales, Inc., which is the first of our big three FAA cases to highlight for next term. So this case is going to be interesting. It's going to bring us sort of like a threshold question. Who has jurisdiction, whose turf starts and ends where the FAA is concerned. And in this case, the dispute centered on an arbitration clause in an agreement, and that arbitration clause said, this agreement shall be governed by the laws of the state of North Carolina. Any dispute arising under or related to this agreement, except for actions seeking injunctive relief and disputes related to trademarks, trade secrets, or other intellectual property of, and then Pelton & Crane, which was the previous company before it was purchased. So, this case presented a question of injunctive relief, which was one of the clearly enumerated exceptions to the arbitration clause. But the arbitration clause also had sort of qualifying language in there that said that both parties probably consented to it by saying that it was in accordance with the American Arbitration Association rules. It stated the location for arbitration. So there was sort of the question, did everybody consent to arbitration? And if so, Or if not, if that's at issue, who makes the decision? And so we saw, definitely some back and forth here. Originally, a magistrate judge took the question and said, we don't have jurisdiction. And then the district court said, no, wait, we definitely have jurisdiction. And so when it goes up to the Court of Appeals, they said, well, what if we don't even ask if we have jurisdiction, and instead we ask, is the issue a wholly groundless inquiry? So the Supreme Court has some options here. They can go down the path of looking into the wholly groundless question, like is this even a matter right for arbitration, or they can go down the jurisdiction path. And it'll be interesting to see how much they decide to clarify.
And this could be interesting, too, in my opinion, just because if the court does decide that these issues need to be decided by an arbitrator, it's almost as if they're kind of handing off anything dealing with arbitration to an arbitrator.
That would absolutely be true. And I wonder if, in Justice Gorsuch's majority opinion dealing with the practicality of the FAA, whether or not this court under this composition would be interested in handing that much power down to an arbitrator, and so this might be an area where Justice Kavanaugh, should he become Justice Kavanaugh, really could sway the court in one direction or another. So it'll be interesting to follow for sure.
We'll have to wait and see. Well, that brings us to our second case that deals with the FAA, and this case really is a nice companion to our Epic Systems case that we talked about earlier. So in Epic Systems, they decided that individual arbitration was permissible. The question here is, in order to have a class arbitration, how clear does that language need to be in the arbitration agreement? So there's 2010 precedent from the Supreme Court called Stolt-Nielsen. And in that case, we know that arbitration agreements that are silent on the availability of class arbitration do not allow for class arbitration. The question here then arises where an employee signed an arbitration agreement that stated that all claims that could have been brought before a court could be brought before the arbitrator. And obviously, class action is something that can be brought before the court. So the question is that enough of a grant of permissibility for class arbitration under Stolt-Nielsen? And what the court will hopefully do here is clarify just how clearly arbitration agreements need to designate that class arbitration is permissible, which they haven't done so far. So it'll be interesting to see how this comes out.
Absolutely. Which takes us to our last of the big three FAA cases, New Prime Incorporated versus Oliveira. Hopefully I'm saying that right. So this case is going to present a couple of questions, and some of them are going to have to do with the same turf wars we talked about before. So we'll see, sort of which decisions come out first. If the court were to decide Henry Schein first, then it might answer one of the questions presented in New Prime Incorporated. But, certainly one question that's really interesting about this case will be, what impact does Section 1 of the FAA have on independent contractor relationships? Does it apply just to employees, or does it also apply to independent contractors? In this case, New Prime operates an interstate trucking company and has sort of an apprentice program where people can come in on sort of a student track program, do some work, build some skills, and then eventually step out to become independent contractors who drive for New Prime, but also have the ability to take business from other companies in need of trucking services. And so here the question is really going to hinge on, whether an independent contractor, because, he was originally not a party to the contract relationship that included the arbitration agreement, can he be bound by it? So it'll certainly be interesting to see. I'll also mention as a caveat that, this could be another decision that's sort of ripe for a more narrow industry-specific holding. We could see the court just weigh in on the impact this has under these facts, and the decision could wind up just impacting independent contractors in the trucking industry. Or, depending on how aggressively the court decides to really clarify the FAA, we could see a more sweeping decision that gives us some insight on how the FAA impacts all independent contractors, employment-wide. Right.
All right, well, that brings us to the end of the case review, but we don't want to leave you empty-handed here. We do want to talk a little bit about judge, or maybe Justice Kavanaugh. And
yeah, you'll see we have a question mark in there.
Right, and what his impact on the court might be if he is in fact appointed. So as everyone likely knows, Justice Kennedy announced his retirement at the end of this term. So his retirement is actually effective July 31st, which is just next week.
John and I are trying to figure out what we think he's doing on his retirement. We assume at least clearing out his office will take a little bit of time.
He's been in office since 1980-something. I can't imagine. I mean, there's got to be a lot to clear out.
He's got a lot of tchotchkes.
Definitely. Well, on July 9th, President Trump nominated 10th Circuit Court of Appeals Judge Kavanaugh to fill the vacancy that is created by Justice Kennedy's retirement. And there's been a lot in the news about Judge Kavanaugh, possibly Justice Kavanaugh. And so we don't want to rehash everything that's been in the news, but we do want to take a focus on what his impacts might be for labor and employment and what that might mean for you.
And, certainly there are a few things that have been in the news that while we won't do a rehash are at least fun to kind of mention. I want to give a shout out to Illinois Senator Dick Durbin, who had a pretty great quote about Judge Kavanaugh during his confirmation hearings in 2004 for the D.C. Court of Appeals, and Dick Durbin made sort of a headline-worthy comparison, saying to Judge Kavanaugh that it seems like you're the Zelig or Forrest Gump of Republican politics. You show up at every scene of crime. So obviously, I don't think he was accusing him of being at crime scenes, but I think his point was more that, Judge Kavanaugh's been a central figure at historically important, big Republican functions or events for many years. So I think, a lot of people know he clerked for Justice Kennedy and was part of Ken Starr's investigation into Bill Clinton, but he was present for a lot of other things, too. He was involved in representing the American relatives of Elian Gonzalez, if you remember that controversy. He also was involved in the recount cases in Florida during the Bush campaign and the Bush v. Gore recounts. And then he worked in the Bush White House as both a lawyer and a staff secretary, all before being confirmed to the D.C. Circuit Court in 2006. So when we talk about someone who's a real Washington insider, he's definitely been around Republican Party politics for a while.
That's definitely true, and his paper trail is part of what makes it possible for us to somewhat comfortably talk about what his impact on labor and employment might be, because there is quite a bit of information out there.
Absolutely. He's been a prolific writer on the court. He's written a lot of decisions, and that's given us some to sort of glean from, were he to be confirmed, what could we expect?
And just as a preliminary matter, so the next few slides, the information is from Empirical SCOTUS, which has done a great job of really compiling his decisions and statistics on him to let us know basically where he might go. And this particular graph shows where he sits on the 10th Circuit, where he currently sits as a judge. So Empirical SCOTUS, from -3, which is the most liberal, to +3, which is the most conservative, ranked all of the 10th Circuit judges, and it turned out that the average center, if you will, for the 10th Circuit is about a 0.5. And we see here that Judge Kavanaugh sits at a 1.54. So certainly he is right of center. That might not be a huge deal, though, because Justice Kennedy himself was right of center. And we can see here that Kavanaugh, although he is right of center, is not the most right of center, even within his own district, or his own circuit, rather, which is a rather small sampling compared to nationwide. So, yes, he'll be right of center. How much more right of center than Kennedy, we don't know, but we'll keep an eye on that.
I think it's interesting as well, because the idea of Justice Gorsuch replacing Justice Scalia, you had a conservative justice replacing a conservative justice. Here, with Justice Kennedy having played the swing vote in so many different cases, if Justice Kavanaugh becomes a thing, if Judge Kavanaugh is confirmed, then, whether or not he'll play the same swing vote is certainly a question. And I think he's probably far enough right of center that he may not do that, and we may see Chief Justice Roberts fill that role in some places. But it certainly is interesting to see, where he really falls on the line inside of D.C. Circuit.
Definitely.
And so one thing we, looked at, because he is such a prolific writer, we were able to see from this chart at Empirical SCOTUS the types of opinions he's written based on the parties involved. And so, employers will be happy to see that in 13 cases involving employee-employer relationships, Judge Kavanaugh 13 times decided for the employer. So in that capacity, he's batting 1,000. And, that's certainly interesting for our purposes here, but probably shouldn't be given too much weight. Throughout his career, Judge Kavanaugh has always relied very heavily on precedent and relied on precedent, and has actually co-authored a book with a number of other authors on precedent. We know that that's important to him. And we also see in some of his decisions involving the NLRB or the union that he's a little more divided. So, specifically, you'll see at the bottom of the chart, in cases that were either for or against the NLRB, 3 different times he cited against them, but 5 different times he cited for them. And with union cases, he was split evenly 2 and 2. So, we can expect, I think, some thoughtful deliberation, regardless of party affiliation. I haven't heard anyone say that Judge Kavanaugh isn't incredibly smart and deliberate. So,
yes, it seems to be pretty universally agreed that he is very intelligent. I would just point out, too, though, that his track record does show that he is rather anti-agency, but he does, from everything I've read, he does take an individualistic approach even to those cases that do involve agencies.
Absolutely. I think we can continue to see that anti-agency trend continue, and, it'll be interesting to see if it doesn't. That would surprise me. And one sort of last chart in sort of contemplating Judge Kavanaugh, we know that he and Justice Gorsuch both used the clerk for Justice Kennedy when he was on the bench. So we thought we'd just take a look at where Judge Kavanaugh's clerks have gone amongst the justices of the Supreme Court. And you'll see at the top that Justice Kennedy and Chief Justice Roberts, by and large, took the most of Judge Kavanaugh's clerks in their ascent to the Supreme Court, and both represent, fairly centrist, or at least on some occasions more centrist than some of their conservative counterparts judges. So, it seems as though Judge Kavanaugh may be surrounding himself with people who are centrist or perhaps less right of center than people believe.
Right, and clearly not indicative of his personal beliefs, but it is interesting to see who he surrounds himself with and where they end up going.
Absolutely.
All right, well, that is our presentation for the day. Thank you so much for joining us. If you did end up sending a question and it doesn't look like we're going to have time to answer, feel free to email us, and we'll do our best to get back to you in a timely manner. I've provided our email addresses here, and they're also available on the second slide. And I just want to say personally, thank you for joining us for what was hopefully informative and interesting.
Absolutely. I'd reiterate, we appreciate you being here so much, and if we've said anything that raises any additional questions for you, please send us an email. We'd also say that we hope you found today's program helpful, and you'll receive an email today with the link to the program's recording should you want to go back and check it out again. Also, you'll receive a survey, and that survey will help you receive the professional credit for your respective certifications. So please fill that out. Thanks so much, and have a great afternoon.